Our top story, the top court will be hearing petition today seeking review of powers of the Enforcement Directorate. The Chief Justice of India-led bench will carry out an in-chamber hearing. The petition was filed by Karti Chidambaram and will come up before the three-judge bench headed by Chief Justice of India, Justice N.V. Ramana. Remember, the top court had validated ED's powers in its order in July.
Bench headed by Chief Justice N.V. Ramana, Justices Dinesh Maheshwari and C.T. Ravi Kumar will hear the petition filed by Congress leader and accused in the INX media case, Karti Chidambaram, seeking a relook and review of the July 27 judgment of the Supreme Court, which had in fact upheld amendments in the PMLA Act that gave sweeping powers to the ED vis-a-vis arrest, search, seizure, and using confessional statements before ED officials. In the review petition, Karti has said there are glaring error on the face of the record, and the judgment upheld various provisions which are in violation of principles of natural justice, right to a free and fair trial, and one which forces a person to be a witness against oneself, giving self-incriminating evidence. So the review petition will be heard at 1:20 p.m. in chamber as per the procedure, and along with the review plea, Chidambaram has also attached two separate applications seeking permission for the matter to be heard in open court, and there's another application seeking stay of the top court judgment of July 27. So today, during the hearing in chamber, if the bench prima facie feels that there is a merit in the review plea, it can order for an open court hearing. On that day, it can even issue notice to the ED and the center and decide whether to stay the July 27 judgment as requested and prayed by Karti Chidambaram. Remember, Karti Chidambaram, who had immediately after the July 27 judgment said the ED had become a weapon of mass destruction, has cited in his review plea more than 40 grounds to legally challenge the judgment.
All right, now let's understand what that verdict actually meant. What are the objections to it? Joining us this morning is Aditya Singh, an advocate, also Khusbu Jain, an advocate, joining us. Thanks very much for speaking to Mirror Now. Aditya Singh, much has been said and debated about the Supreme Court verdict on the Prevention of Money Laundering Act. What do you make of that judgment? Do you agree with the Supreme Court? Do you have objections to it? Mr. Singh, can you unmute and speak?
Yeah. So basically, in my opinion, certain basic principles of criminal law and constitutional jurisprudence cannot be whisked away. And I do feel that the three-judge bench of the Supreme Court, in their rulings on the PMLA Act, had apparently appear to have transcended some basic concepts, like statement of the accused person being admissible, then not even giving a copy of the ECIR. So I do feel that the three-judge bench of the Supreme Court needs a review, and I'm happy that a hearing on the review is likely to take place, and probably some of the omissions in the said ruling can be rectified.
Khusbu Jain, the ED officers are empowered to record admissible statements. They have additional powers of search and seizure, subject to the ratification of the adjudicating authority. And then there are additional restrictions on the grant of bail under the PMLA. The Supreme Court has, however, said that the CRPC provisions and PMLA can't be compared. Do you agree with that?
Yes, to an extent, I agree. Agree that. Am I audible?
Yes. Go ahead, ma'am.
Yes, to an extent I agree, because see, one has to understand that a PMLA grants a special power, and this is being done in a special, it's done in a special cases. But to understand that what kind of cases that come under PMLA that can deal with crimes which can be part of terrorism, crimes very harsh, where there are harsh punishments. So in order to mellow down, or in order to understand, that's where the interpretation came that this can lead to arbitrariness, and any scope of arbitrariness can result into an unjust and unconstitutional, and can have an unbearable consequences on the accused, in case those accused are set free or are not convicted at the last. So to understand, or to bring in the parallel instances where all the discussion is all about, is all going on. So to point it, one has to understand that the utility of independent provision of forfeiture is distinct from criminal prosecution, and that needs to be utilized in a proportional. I mean, I want to repeat that it has to be utilized in a proportional manner, looking at the gravity of the offense. As I earlier said, it can be in the matter of crimes involving terrorism, crimes involving drug cartels, or organized crime activities. But one also has to understand that this muster of proportionality for having such stringent civil forfeiture has to be related to these serious crimes only. Now, also, application of such a provision to numerous other offenses which are not of such grave severity would be of a serious risk of being disproportionate if procedural independent of criminal prosecution are prescribed. So these two aspects, I think one has to be looked in, and that's what I think the courts are also observing, that at such arbitrary, or they have to utilization or applicability of the section which has been provided, the power provided of civil forfeiture of forfeiture has to be utilized.
Ma'am, if I may just come in there, then how do you ensure, you're talking about the proportionality, how do you ensure that the procedural follow-up are strict so that the rights of citizens are not compromised?
See, there are rules which have been prescribed, the 2016 rules, which specifically put in guidelines as to in what manner and how things have to be observed, and how have to be conducted by the officers. Also, a civil forfeiture is different from a criminal forfeiture under IPC of section 53, and civil forfeiture needs to be proportional and not arbitrary. Now, to have it a clarity, I think the 2016 rules, the rules which specifically talks about the forfeiture and how the conduct has to be strictly observed and followed by the officer, and in the absence, harsh action should be taken against those officers. That's the only way one has to look in, because this specific provision has to be used sparingly by the officers. It cannot be in each and every cases.
Yes, Aditya Singh, to be fair, doesn't the PMLA also have penalties against the erring officers? So isn't that a safeguard enough in the Act?
Can you repeat? Can you just repeat?
Aditya, I was saying, doesn't the PMLA also have penalties against the erring officers? So is that a good enough safeguard in the Act?
Well, ultimately, like essentially, if an officer is, launches maybe a frivolous prosecution or a false information report, I believe it will not be a very sufficient safeguard, for the simple reason that convictions of officers for registering false reports, or because a lot of the officers' protection ends up getting protected under the ground that he had acted bona fide in public interest in the discharge of his duties. So I do feel in such a case, and of course, one thing is that a person always has a civil remedy. He has a remedy of approaching the human rights commission. He has registered a false case against him. But I do feel that one needs more safeguards, for these remedies also take a lot of time here.
Right.
Trial altogether, separate proceedings altogether. The officer will have to defend himself. Plus, these days, the officers are so much heavily protected by the tag of being a public servant acting in discharge of a public duty, that it does become, very difficult. So what I feel is inbuilt safeguards, like, such as maybe showing the income from proceeds of crime.
All right. All right, Aditya Singh and Khusbu Jain, thanks very much for speaking to us, sharing your perspective on this story. We'll wait and see what happens in court today when that petition is heard. Thanks very much. Indeed, some breaking news coming in from Bihar.